So in a residential context or in a commercial context, when your lease doesn't allow you to lock out a tenant, the only way that you can retake possession of the premises is through a judicial eviction. And in Texas, evictions are called forcible entry and detainer proceedings. They're held in the Justice of the Peace Court in the district where the real estate, where the premises, the property is located. They're very simple and they're in justice court, so they're often done by an individual. You don't need a lawyer. You don't need a lawyer in justice court for anything. And they're simple, but they do have requirements and you have to make sure that you meet them all. You've got to make sure that you name not just the tenant, but anyone who may be an occupant there. The sort of magic phrase, all other occupants, doesn't work. You've got to get notice for every single person who's in the property. You've got to verify your complaint, which means you've got to swear that it's true. These things are easy to do, but you want to make sure that you do them all before you file your document. The court is very flexible because this is usually being done by property managers or non-lawyers, but you still have to meet those requirements. If you don't, then your tenant can defeat your eviction and you'll have wasted months of time, which in a rent situation, you're losing that rent. Assuming that you've performed your steps correctly, the judge will give you a judgment for possession of the property. Once that judgment is entered, there's a very brief appeal period, and after 5 days, you can get a writ of possession. The writ of possession is instructions for the sheriff to go to the property and forcibly detain the tenant. That's why it's called a forcible entry and detainer proceeding. Be prepared to tell the judge the amount of rent. They'll write it down in their judgment and in their order because that's the amount of money that the tenant will have to deposit in the court's registry if the tenant appeals the case. So you've got to be ready with that number, and some of the judges are not so patient. So any appeal will go to the county court at law. The justice court is not a court of record, so there's no record of what you've done, so everything is kind of a start over fresh. At the county court at law, you will appeal, you represent your case, and then the tenant can present it as well. In order to make that appeal, the tenant has to have deposited rent in order to make the appeal and to continue to reside at the residence during the appeal.